Courtmaster sir, we are unable to see the Honorable Court. We are unable to view the court, sir. Sir, the video came and again it left, sir.
One ಮೇಲೆ ಆನ್ ಆಗುತ್ತೆ ಸರ್ ವಿಡಿಯೋ.
Thank you, sir.
Number 3.
Make a petition of
List number 3 for pronouncement of judgment in commercial appeal 229 of 2025.
In view of foregoing the award of the arbitral tribunal for payment of 8,65,99,649, whether the interest at 8% as well as payment of 1,09,17,991 for purchase of software storage of use. Yes, with service tax are set aside. The remaining portion of the award is not interfered with. The parties are at liberty to initiate fresh arbitration proceedings with regard to the consultancy fee payable between 1/8/2014 and 28/2/2015. The appeal is disposed of in the aforesaid terms.
Any mentions?
May I make one mention, my lord?
May I make on submission?
56 in the first list.
Yes.
Against the final order of the commercial court. But I had got a document called a permanent perpetual lease in 2005 by paying 58 crores.
Yes.
The total FAR on the land that was purchased by me was not given. Trial court now has decreed my suit. They filed an appeal against the June 25 judgment. No stay is granted by your lordships. But they are putting up construction, my lord. The only reason is this: if they utilize the FIR which inures to my benefit, then a situation would arise, my lord. If your lordship could fix a date, my lord, in the second list, any day that is convenient to the court, my lord.
We'll start today. We will start today. We'll take it up.
The other side has to start. I'll take my chance, my lord.
My lord, I'm respondent number 5, 14% in serial number 57.
Yes. 57.
Yes.
35.
Yes. It's for final order. My humble request.
All right, we'll take it.
My lord, sir.
Petition serial number 28, this number 2, my lord. The AG was asked to appear today in the afternoon. And I'll seek insight from the councils, my lord, and submit. Given it's not.
Is Mr. Kamath here? Not here.
My lord, yes, not the man is being today. I'll ask him to appear. Councils who are appearing for the petition and the accused.
Is the DSG there? Is the Mr. Shanti Bhushan here somewhere?
I'll
Ask him. We are calling up one of the. We found prima facie view that one of the commissioners is willfully flouted our orders. We want him to be present now. So yes, before we ask any further course of steps, let him. You have to take instructions to file your response.
Yes, well, I will seek him, take instruction from them, my lord. I will ask contribution to appear or the AG to appear. Today, my lord, there's something. That's the reason. Because I appeared in the writ.
We'll put it tomorrow. Ask the AG.
My lord, list number 2, serial number 11, my lord. I'm held up in another court, my lord. Notice may be ordered, my lord.
Yes.
List number 2, serial number 11, my lord. I'm the complainant in this case now. Notice may be ordered, my lord.
11.
I could not reach in time, my lord.
No one appeared in this.
I could not reach in time, my lord, because.
So what is the date we are giving?
Notice may be ordered, my lord. Notice not.
All I'm saying is giving issue notice.
Grateful, my lord.
List 1, serial number 20, my lordship, for the petitioner.
Yeah.
We have engaged senior counsel. However, there is some personal inconvenience for him. My lordship may kindly have it on any other day.
Request for adjournment is made by the Lieutenant Counsel to the petitioner. I do request this.
My lord, 21st April.
Wait.
My lord, just a submission, my lord.
My lords, one humble submission, my lords.
Yes.
My lords, list number 1, serial number 9, my lords. The main counsel on record couldn't be able to present today. He's getting married on 18th this month. Any date after 6th March may be fine.
A request for adjournment is made by the learned counsel for the appellant. It is stated that the counsel who has to advance submission is getting married. List on.
27th April.
Lords, I filed a fresh matter.
Much obliged.
I filed a fresh matter on the 5th of February, my lords. Construction is happening in the unauthorized construction is happening in the buffer zone of a tank.
When did you finish when did you cure your defects?
My lords, day before, my lords.
Wait 3 days, 4 days and one day.
The Lordship's kind permission, serial number 16, my lord. First list. The board and memo of adjournment has served a copy on the petitioner counsel also. Additional documents regarding compliance, 4 weeks. I have intimated the counsel for the petitioner.
No.
21/4.
Lord, commercial appeal 304 of 24, my lords. It is to be listed, my lords. I'm just moving from memo for posting for the matter to be listed.
When did you cure the defects?
My lord, I am the respondent in this matter has been heard couple of times, my lord. A date was not given, so the matter is not listed.
When
For
was
the
it last listed?
listed around November, my lords.
Date will be given.
So therefore, I'm giving matter is no, my lord. The court officer also just checked in the morning, my lord. There's no date.
It's not here. It is not here. Fix a date.
Therefore, my lord, obliging.
But one mentioning, my lords, it's a contempt matter, my lords, in respect of GST reimbursement, my lords. When this contempt matter was pending, my lords, department has taken certain precipitative actions, my lords. Therefore, in view of urgency, matter may be listed tomorrow. I have put an early hearing application as well, my lords. May be listed tomorrow. Just that, my lord, they may not take any precipitative actions against the complainant. I have initiated a contempt proceedings. When the contempt proceedings was pending, my lord, they have threatened to initiate the precipitative actions against me. Taken up tomorrow, my lord. Date
17. No record is unwell for short accommodation.
All right. Request for adjournment is made by the learned counsel on behalf of the learned counsel of the petitioner. List.
28th April.
Response 8 of 47.
Yes.
The settlement talks ongoing. Matter will visit 2 weeks later.
Who's appearing for the other side?
And for the applicant.
No, who's for the other?
We've informed them. Other side is me.
Learned counsel for the appellant requests for adjournment. He states that the parties are endeavoring to resolve the disputes. That is required listing.
28th April. Any other mentioning? List number 1, seal number 8.
For this plaintiff's appeal, my lord, against the partial decree in commercial suit passed in the recovery of money, my lord.
Yes.
The suit has been partially decreed for 2,20,000 at 10.20%, my lord, instead of 4,19,000, my lord. The reasoning has been given, wrongly has been given that due to COVID-19 pandemic in existence since from December 2019 to March 2022, defendant has ruled that the defendant could not have paid the loan, my lord, without even examining the RBI circular, my lord, to know that whether the defendant was eligible for resolution framework, my lord, and produced the relevant circular, which is at page 132. Loan transactions is admitted, my lord.
No, you were delayed by 180.
Delayed, sir, my lord.
So what is the ground? You couldn't get permission to file.
My lord, I couldn't get the permission from the competent authorities well within the time, my lord, due to shortage of staff.
Competent authority is you. Not some government. The company You're a company.
Yes, ma'am. It's a banking institution.
A banking company.
Yes.
What? You can't get permission. You can't get permission.
But due to shortage of staff, I couldn't get the permissions in time, my lord. Hence, there was a delay, my lord. We condoned, my lord.
You can't say it's 60 days to file it. You can't say that you didn't get permission to file. Can't be a ground for condoning delay. It can't be. What is on your merits?
My lord, the reasoning is given. The impugned judgment is at page 24, my lord. That is a judgment. The defendant has taken specific contention in the written statement, my lord, that due to COVID-19 pandemic, the business was undergone loss. As such, he couldn't pay the amount, and the bank has not considered the resolution framework issued for the COVID-19 pandemic borrowers for MSME sector, my lord. And the relevant, the issue framed is at page 30, my lord. Issue number 2.
Issue notice.
Not some advocate has filed wakalat, my lord.
Who's filed? Who's for the respondent?
Some Prasanna Kumar name is showing me.
You file the paper book. Let the paper book be filed. Don't say notice. Let the paper book be filed before the next date of hearing.
3rd of June.
Right.
9 addendum number 10.
For the petition in this case, Lords.
Lordships, I appear on behalf of the respondent. I am appearing online, Lordships.
Lord, shall I come, Lord?
Yes.
On 17/12/24, Lord, the respondent is preferred in application AA number 442/24 and sought for declare that the respondent is in breach of the obligation under purchase order bearing so number 9/10/23 and also sought for mandatory injunction and also sought to furnish the security amount equal to 14 crores 62,000 50,146 rupees. My lord, this appellant has preferred a written statement explained about how the transaction takes place and came to existence. The respondent has preferred an additional statement also. We have filed this additional objection also. The learned judge has passed an order directing the petition to furnish the security amount equivalent to 14 crores 62 lakhs 50,146. That is the claim made by the respondent before the commercial court. The entire amount of 14 crores 60,000 50,146, Lord, he has ordered. That order challenged by that order passed by the learned judge is under challenge before some court. The Lordship, I can see page number Lord, the order 68, the order for the passed by the commercial court. Lord.
Yes.
The application for 68, page number 68, Lord. The application filed by the applicant under section 9 of the Arbitration Conciliation Act 1986 hereby allowed in part. The respondent, their legal representatives, assignees, administrators, men, servants, and employees, or anyone acting through or under it or hereby destroying by way of order of mandatory injunction from creating any third-party interest or from alienating in any manner with respect to the the machinery plant located in Ujjain, address at flat number 103 and 104 110-116 Vikram Udyogpuri, Ujjain, Madhya Pradesh. Then, Lord, for this absolutely we don't have any objection. We don't alienate. We have made the submission before the court below itself. We don't create any third-party interest. We don't alienate into the third party, to any third party, or we don't create any third-party interest as such. The last paragraph of this particular order, my lord, that is page number 69. The respondent is hereby directed to furnish security amount equivalent to 14 crores 62 lakhs 50,146. This is the claim amount. Your lordship, I can say the very claim amount it is 14 lakhs 62,146. Because he has ordered. No? My lord, by the time, my lord, arbitrator was appointed. Arbitrator was also appointed to the order dated By the blood, when the matter is pending before this commercial court, my lord, they preferred one application for the appointment of the arbitrator, my lord, that is CMP number 60 of 2025. There is an application which is pending before this Honorable High Court, my lord. Filed on 1/2/25, they preferred this application. Lord, received the notice on 24/4/2025. On 6/6/25, petitioner, Lord, I made a submission before the court stating that they have already filed an application for appointment of the arbitrator. In such an event, the question of passing any orders by this commercial court does not rise. That is the submission which was made before the court below. Lord, on 13/6, I made the submission on 6/6/25, and not on 13/6/25, he has passed an order directed to deposit directed to deposit 14 crores and add rupees below. CMP order passed on 23/6/25. I made a submission on 6/6/25 regarding the application which was filed by this respondent for appointment of the arbitrator. Lord, in such an event, Lord, this is claim amount. It has to be decided. It has to be decided by the honorable arbitrator, Lord. Without looking any of my submissions, without taking into consideration, he has passed an order which is totally illegal and unsustainable. Lord, hence this order passed by the judge has to be stayed by this honorable court. Lord, your lordship may come to see. Then, my lord, your lordship may come to the grounds which I have made before this honorable court. Lordship may page number, Lord, 26, lords. 26. The grounds which are made before this honorable court is this. The impugned order virtually grant final monetary relief at an interim stage by directive deposit 14 crores, which is impermissible under section 9 of the Arbitration and Conciliation Act of 1996. I mean, section is protective, not 912B is protective and preservative in nature. It permits only to secure the amount in dispute and does not empower the court to adjudicate upon liability, quantify any portion of the claim or determine the amount likely to be payable. That is by the second ground which I made out. The direction to deposit 14 crores and add, constituting the total claim of the respondent, which is arbitrary, disproportionate, and oppressive, particularly when the entire claim is disputed, no amount is admitted, and the arbitration proceedings are pending. Lord, by directing the deposit the quantified sum, the learned district judge has prejudiced the merits of the dispute and assumed the law reserved exclusively for arbitral tribunal, thereby encroaching upon its jurisdiction. That is the fourth ground which is made out, my lord. There is no finding in the impugned order that the appellant is dissipating the assets, acting to frustrate the arbitral proceedings, or financially incapable of satisfying the future arbitral award. In the absence of such findings, the direction to deposit 14 crores is unsustainable in law. Then, my lord, a deposit order under section 912B can be passed only upon the clear and specific finding that the respondent has established a strong prima facie case and that there exists a real and imminent risk of arbitral award of being rendered nugatory. The impugned order contains no such findings. The sectoral law in interim measures under section 9 are governed by the principles applicable in section in order 39 of the Code of Procedure. The learned district judge has failed to record any findings on prima facie case. Balance of convenience are impermissible. Lordship may can see. And this, my lord, the arbitral has already been constituted and seized the dispute. Adequate and efficacious remedies are available to the respondent of section 7 of the Act, 17 of the Act. The impugned order, therefore, undermines the arbitral process. While section 912B empowers the court to secure the amount of the dispute, such a power is preventive and not determinative. It cannot be exercised to grant the final relief, even indirectly, or to decide the merits of the dispute. In such an event, my lord, lordship I can say, the order passed by the learned judge, my lord. Lord, without taking any, my lord, if it is referred to the arbitrator, there, my lord, we have already filed the statement, claim they have made, and the statement of objection I have preferred, and my lord, the 17 applications they preferred. Lord, there I have given a clear, this one, my lord, this one, stating that we don't alienate this property, and we don't create any third party interest, and all those undertakings are given. Despite that, my lord, this 14 crores, my lord, it is a claim made by this particular respondent. The whole amount was ordered by the learned judge, which is totally illegal and unsustainable. That is my grounds, please.
Yes.
And my lord, we will not say this. My lord, 1 second. My lord, one of the judgment, my lord, there, my lord, That's why I quote this particular judgment. Then Adhunik Steel Limited versus Orissa Manganese and Minerals Limited.
Now let me know the
Please, this also is solved. Lord, in such a the order passed by the judge of the court has to be stayed, or else, anyway, this arbitration.
Adhunik may not apply because in this case, you need a specific government that you are selling the plant.
That's right. In the meantime, Lord, now the arbitrator has already commenced this arbitral proceedings. Your Lordship can refer this particular issue, you will before the arbitrator, my Lord, we will let the arbitrator decide this matter. That's also for it.
Yes.
With Lordship's permission, may I make submission, Lordships?
Yes.
Only on legal points, Lordships. So statutory provision under Section 9 is very clear that a party before or during arbitral proceedings or at any time after the making arbitral award, Section 9 interim measures and application for interim measures can be moved. The subsection 1 and 2 also clearly says that any order can be passed to secure the amount in dispute in the arbitration. So I had moved Section 9 application because there is an admitted position, and kindly refer the impugn order at page 65. Paragraph 57 of the impugn order.
Yes.
It clearly says the learned counsel for the applicant, I was the applicant in the Section 9 proceedings, brought to the notice to this court regarding the paper publication where the respondent, who is the present applicant in these proceedings, on 16/11/2024 has published calling upon expression of interest for the sale of 7 ACA plant in construction located in Ujjain on as is where is basis. This is the plant where I had supplied machineries, and against those machineries, my payables are due. And in paragraph 58, this is the admitted position. Admittedly, the respondent has not denied the issuance of paper publication. Hence, the commercial court invoking the subsection 1 of Section 9 had correctly observed and directed to secure that amount because the appellant in these proceedings is in the process of selling the plant. That's my first humble submission. And look at the grounds of the present applicant, which are completely self-destructive. Kindly see the page 26. My learned friend has also read out a couple of portions at page 26 of his present appeal, para 23. Whether Lordships have it?
Let us look at your amendments regarding.
Yes. My Section 9 is attached at page number 70 to 85.
Yes.
Kindly see specific para at para 41 at page 80. This is my Section 9 application. And it clearly says the applicant petitioner further states that applicant apprehends that if the respondent is successful in selling Ujjain BD plant, the subsequent purchaser may not oblige the contract, which will lead to irreparable loss to the applicant. More so, it will also lead multiplicity of proceedings and litigation. Hence, it is utmost necessary to restrain respondent from making any transactions of the Ujjain BD plant. So that's the specific proceedings, Lordships.
Yes.
And kindly see now the present appeal, paragraph, page 26, paragraph 23. And his own grounds are self-destructive. On one hand, Lordships, he says that at para 23 in his grounds, Section 9(1).
What is your claim? What is the claim? What is your
My
claim?
claim amount is 14 crore.
Where is that articulated?
It is articulated at page
In your section 9 application.
Yes, Lordship. Kindly bear with me. So at paragraph 31,
Yes.
page 78.
No, but this claim is just saying secure a claim of 1462. But what is this claim?
It is against the machinery which I have supplied to the appellant.
Therefore, we are asking you, where have you articulated this, of how this amount comes about?
So kindly see the table at page 77 as well. Paragraph 28, which narrates the entire history. The purchase order was of 52 CR, against which I had also furnished the advance bank guarantees. In that table, I have narrated everything, which comes to around 23 crores.
You accept that they've made partial payment of 9 crores 36 lakhs.
Yes, Lordship. And kindly see now the para 31. So they have made partial payments, and hence the outstanding amount is 14 crores 62 lakhs, which is pleaded in my paragraph 31.
We're asking you how. You showed us 31. This 14 out comes from which figure?
So
you have said they paid you 9 crores 36. Where have you said what is the invoice raised against which they paid you? How much is therefore left? Where is that breakup?
So unfortunately, Lordship, the appellant has not filed all supporting documents which I had moved along with my section 9 application. And when I moved this section 9 application, 5 crore payment was made by them. And this 14 crore was outstanding as per the paragraph 31, where I have admitted out of 23 CR, they have made partial payment of 7 crore, and that 14.62 remains outstanding as per paragraph 31.
You look at the table, payment of advance bank guarantee.
Yes, Lordship.
What is this? Bank guarantee is not payment, no? This is a bank guarantee you've given.
So it's an advance. It's an advance bank guarantee. The advance was released against which, because it was subsequently due, Lordship. Advance bank guarantee was towards the mobilization of material and mobilization of labor, so which I had furnished. Then there is a 60.
You had furnished a bank guarantee.
Yes, it was towards advance bank guarantee, advance payment.
Yes, so now has it been encashed?
Not encashed. It was not encashed, but after I delivered the two.
How will you be paid for your bank guarantee? And the bank guarantee is a guarantee. Unless it is encashed, there will be no debt to you, no?
Absolutely, Lordship. There are two types of bank guarantees. One is advance bank guarantee and one is subsequent bank guarantee. So advance is furnished towards the advance payments made by the buyer, for which advance is paid towards the mobilization of labor, mobilization of raw material and everything. And when I supplied the materials, that advance bank guarantee has to be returned. So my money is stuck in the form of bank guarantee. Then there are
This can't form a part of your security. He can't furnish you a security for your bank guarantee.
Right. So, Lordship, the question here is the entire plant at Ujjain, where I have supplied my machines, is about to be sold off. So, where would I go? My huge stake of 14 crore is at stake. So, where would I go?
Is there anything in your pleadings to show what this 14 crores is about?
Pardon, Lordship?
Is there any breakup of what this 14 crores is about? Bank guarantee can't be an amount to secure. You can get an order restraining them from invoking the bank guarantee. That's a separate issue. But they can't give you security.
Right. Lordship, kindly allow me. I will file my affidavit in reply and I will prepare submit that breakup of 14 CR outstanding amount in entirety.
No, but that's not there before the commercial court.
It was. Unfortunately, the appellant has not attached the entire compilation. He has only filed the Section 9 application.
But Section 9 application doesn't state it, no?
So it says, paragraph 31 says, and I have attached all breakup along with my compilation, which was filed in Section 9 application. I had also annexed the invoices as well along with Section 9 application. Here, the appellant has only attached the Section 9 application, not the compilation which was filed before commercial court. So kindly allow me, I will bring on record everything on affidavit in reply.
Do you have a breakup of this?
Please note.
Do you have a breakup of this?
Breakup of this, my lord, sir. Lord, 3 fermenters they have supplied. For that, my lord, 23 crores and all. Remaining amount we have already paid. Remaining of only 14 crores it is left.
No, but this.
In this regard, my lord,
this includes 7.68 crores of bank guarantee.
Please note.
That bank guarantee is a live bank guarantee.
Please note. In such an event, my lord, the answer is for this, my lord. Then, my lord, actually, my lord, after supplying the 3 fermenters, my lord, we have made certain amounts, and they said that is only 14 crores which is left. No, we have not yet paid like that. That is their claim. My lord, the entire claim, my lord, that cannot be decided by the commercial court. That is my question. That is my answer. 14 crores, whatever it is there, that cannot be decided by this particular. That cannot be decided by only after reading the evidence and producing the documents and cross-examination. Then only it has to be right. But only entire claim, my lord, it is allowed by the commercial court, which is totally illegal and sustainable. Only that.
And lordship, it was admitted over and over again by the present appellant. Yes, this amount is payable to the respondent. It was made. This submission was made before commercial court a number of times and before the present arbitration tribunal as well. There is no dispute of amount.
We can't find your amount from this petition. We have gone through
Kindly
it.
allow me to file affidavit in reply. I will
we have really no idea how this 14 crores comes. It assumes that 9 crores you have admitted, 23 crore table you have given, the balance seems to be 14 crores. This 23 crores includes a bank guarantee which you have given, which is not encashed. So obviously he can't give you a security for that amount.
I will file. Kindly allow me to file.
You've asked, you said you've supplied the plant and he's selling it, and therefore you require an order restraining him from selling it. You can't restrain him from selling his assets and yet take a security. Both will overlap. If you want to secure your claim, you can only secure your claim by one security. According to you, even if we accept only 14 crores is payable, and that is against supply, after having injuncted the person from selling any asset of his, where is the question of further security?
Right, lordship, it's not only I am the only supplier. There
you
have
are the unpaid seller, no?
Yes, lordship.
An unpaid seller and you may want security for the amount, or you may want security for the assets. Having got the security from the assets, you can't replicate it again. All his assets, he is restrained from selling all his assets. Where else is?
Right. Lordship, kindly allow me to put it on record by way of affidavit.
We'll modify this order to let the security amount be. He will not alienate any of his assets.
Yes, we are ready to give the transfer. We don't transfer. We don't alienate.
You can argue your claim before the arbitral tribunal.
Please note.
Yes, lordship. All rights and contentions be kindly kept open before arbitration tribunal.
That's right.
Please.
This is an application filed for condonation of delay of 118 days. The appellant states that he had filed a writ petition which was not maintainable, and thereafter numbered the present appeal as an MFA. Full stop. In view of the above, the application seeking condonation of delay is allowed. Next para. Right. Next para. The appellant has filed the present appeal under section 37(1)(b) of the Arbitration and Conciliation Act 1996, impugning an order dated 13 June 2025, passed by the Learned Commercial Court, give this full name, by the Learned 89th Additional City Civil and Sessions Judge, Bengaluru, bracket Commercial Court, bracket close, in Com AA number 442 of 2024. Full stop. The respondent had filed the said application under section 9 of the ANC Act, seeking interim measures of protection. Full stop. The respondent had sought an order and I'd filed the said application inter alia praying as under. Just take it from page 81. Just say A and B. Don't have to. Next paragraph. Here's the plain reading of the application. The Learned Commercial Court had allowed the said application and had restrained the appellant from creating any third party interest or in any manner alienating the the plant described as 7-aminocephalophoric acid bracket 7-ACA plant located in Ujjain at plot number 103 and 104, 110, 116, Vikram Udyogpuri, Ujjain, Madhya Pradesh. Next paragraph. Additionally, the Learned Commercial Court had also directed the appellant to furnish a security equivalent to rupees 462,50,146, rupees 14 crores 62 lakhs 50,146 only. Next paragraph. The appellant had filed a said application. The respondent had filed a said application seeking interim measure of protection in the context of the claims, in the context of its claim for payment of the plant supplied. Full stop. The parties state that the appellant had the parties had entered into a techno-commercial discussion on 7th August 2023. Or just before that, say the appellant had floated a tender for supply, installation, commissioning, and validation of fermenter with agitator assembly bracket 250 KL on 14 June 2023. Full stop. The respondent had furnished his bid pursuant to the invitation, and was declared a successful bidder. The respondent agreed to manufacture, supply, install, and commission fermenter with agitator assembly as per specifications. The appellant had in terms of the contract between the parties. Or before that, after discussions, the appellant had issued a purchase order dated 9th October 2023. In terms of the said purchase order, the respondent was required to supply 8 fermenter bracket 250 KL for a total value of rupees 52, 41, 60, 000, rupees 52 crores, 41 lakhs, 60,000 only. The respondent claims that it has, pursuant to the purchase order, supplied 3 fermenter units. It claims that it is and the total amount. The appellant claims that although it had the claim acknowledges that respondent acknowledges that it received rupees 9, 36, 37, 354. Claims that a further amount of rupees claims that unpaid outstandings. There are unpaid outstandings of rupees 23, 988.75 CR. So paragraph 28 of the application filed under section 9 of the ANC Act is set out below. 28, just at 28 and 31, which set out the respondent's claim. Set out below. Full stop. It is apparent from the respondent has not clearly set out as to how an amount of rupees 14, 62, 50, 146 is being computed. Full stop. Notwithstanding the above, the Learned Commercial Court has acceded to the said prayer and has directed that the security, that the respondent, that the appellant provide the security for the said amount. Next paragraph. It was a respondent's case that it had come across an advertisement calling for expression of interest regarding sale of the Ujjain BD plant. It was thus contended on by the respondent that the appellant was in the process of selling the plant for which the consideration had not been paid. It is in this context that the appellant and respondent had sought interim measures of protection for securing its claim. Paragraph 31 of the application, respondent's application, which contains the relevant averments, is set out below. Full stop. Since the respondent had sought for interim measures of protection for protecting its, for preventing the respondents from selling the assets which, according to the respondent, were supplied by it. An additional, and the same was, since it's supplied, and the same was exceeded to, the further direction to secure respondents' claim would essentially result in interim measures. It will result in overlapping interim measures. If the petitioners, if the respondent's claim is confined to rupees 14, 62, 58, 146, at best the Learned Commercial Court could have granted orders for securing the same, subject to being satisfied that such an order was necessary, and failing which there is the respondents the respondent would be unable to recover the claim. Recover the claimed amount if it succeeds in the arbitral proceedings. Full stop. However, we find that there is no prima facie finding I don't say this. Next. The appellant, we are of the view that since the respondent has sought for an order restraining the appellant from waiving any third-party rights in respect of the plant supplied by it, the said order would be an apposite measure of would adequately secure allay the apprehension that the appellant was in the process or would alienate the said property without any recourse, leaving the respondent without any recourse. Full stop. In the given facts, in view of the above, we consider apposite to modify the impugned order by setting aside the directions to the respondent to provide a security for a sum of rupees 14, 62, 50, 146. The appellant is restrained. The order restraining the respondents, the appellant from alienating the plant in question would continue to be operated. Full stop. Since the arbitral tribunal is, we note that the arbitral tribunal is since been constituted. We clarify that this order would not preclude the parties from seeking further interim measures of protection before the arbitral tribunal, if necessary. Stop. If the respondent is also not precluded from seeking. They also clarify that all rights and intentions of the parties are reserved. And if any application for further interim measures of protection is filed, application for further interim measure of protection or for vacation of the interim measure of protection is filed before the arbitral tribunal. This same may be considered by the tribunal influenced by any observations made in the present order. The appeal is disposed of in the aforesaid terms.
Highly obliged.
Much obliged.
Highly obliged.
Respondent number 3, 4, and 5.
Serial number 11. The petition is for transfer the commercial OS pending before the Honorable Municipal Civil Judge Mysuru to the Commercial Court Bangalore only on the ground of the health issues. The petitioner has undergone the surgery of C1, C2 spinal fusion surgery. But he has advised not to travel and not to climb the stairs. Only on the health ground we are seeking for transfer the petition.
Any objection?
The general power of transfer and withdrawal, my lord, available to this honorable court under section 24 of CPC cannot be read into section 15, subsection 5 of the Commercial Courts Act 2015. But section 15 of Commercial Courts Act, under which this application is filed, applies to those cases of civil nature which were pending prior to the passage of the Commercial Courts Act 2015 to be transferred to the commercial division. But that would not give power to this honorable court to withdraw.
No, this would be under 15, you're right, but this would be under 24. The High Court will always has the power.
Section 24, my lord.
We can. Maybe a wrong nomenclature. That's why we're asking you, is there any...
Now the case is posted for cross-examination of PW1. His presence would be required only for the purpose of cross-examination. He can avail the VC facility, my lord. And also, my lord, a commission may be appointed. He can file an application seeking appointment of a commissioner to record the deposition of PW1. And his presence thereafter is not required. Lord, all the documents are marked. We filed a written statement. His presence now, my lord, the case stands posted on 3rd of March for cross-examination of the applicant. We can avail VC facility, my lord.
Please, brother.
11. The applicant has filed the present application.
But the respondents, my lord, they are insisting the petitioner to be present before the court, my lord, every date of hearing for cross-examination.
Has filed the present application seeking transfer of the proceedings, transfer of the commercial suit being COM OS 142 of 2023 in the Direct Commercial of Honorable Principal District and Sessions Judge Mysore to a commercial court in Bangalore. So, the applicant who is the defendant in the said suit.
Applicant is the plaintiff.
Plaintiff in the said suit.
Plaintiff.
So the applicant, which is a sole proprietorship concern of a plaintiff, The sole proprietor is concerned and the plaintiff in the said suit has sought the transfer on the grounds of his ill health. Full stop. Say this in the on the health of the sole proprietor. The sublearned counsel appearing for the respondents submits that the said application is not maintainable under section 15. The said application under section 15 of the Commercial Courts Act 2015 is not maintainable. However, it does not dispute that said power that this court would have the power to transfer the commercial suit from the Learned Commercial Court in Mysore to Bangalore under section 124 of the CPC. Should stop. On merits, he submits that the matter is listed before the Learned Commercial Court, Mysuru, and on 3rd March. For cross-examination of examination of PW1. And if he is unwell, you can also see.
Examination in chief is over.
Examination, documents are not.
Cross-examination.
On the stage for cross of PW1.
Of PW1. And if the proprietor, the sole proprietor of the plaintiff, in the bracket, and if he is unwell and if he cannot travel to Mysuru, the cross-examination will be conducted through video conferencing. He also submits that the respondent would have no objection if a court commissioner is appointed for conducting the cross-examination in Bangalore. The sublearned counsel appearing for the applicant submits that be satisfied with the said suggestion if the said suggestion is implemented. In view of the above, we dispose of the present petition by granting liberty to the applicant to file an appropriate application seeking to seek that the recording of further evidence be conducted through a court commissioner. And in his case, in the case of PW1 at Bangalore, the Learned Commercial Court, if such an application is made, the Learned Commercial Court should consider the same sympathetically. The application is disposed of for the aforesaid.
May I make one more submission, madam? Further direction for disposal of the earliest, if possible.
It's all right. That's not your 15.
Is seal number 12?
Lords, the matter is arising under the provisions of the ST-PCL Act. Lords, the orders of the Assistant Commissioner and the Deputy Commissioner has not been interfered with by the learned single judge. Considering the fact that the proceedings are initiated within a period of 6 years and much lesser also in respect of some cases. Lords, the only direction, if your lordships were to see, in page 101, the conclusion. The learned single judge records categorical finding that this is not covered under a country's case. It's a granted land, there is a violation of the grant conditions.
Yes.
Lords, and then, if your lordships were to see the consequences at page 102.
Yes.
Lords, I just read conclusion and then take your lordships to that. Page 101. As noted above, the petitions have not been able to establish Chikkanagappa, Munyappa, the original grantors, obtain any permission from the concerned authorities as contemplated under the provisions of the PTCL Act to alienate the granted land. Petitions are also not able to establish that there is a transfer of subject land with the meaning of section 3(1) of the KPCL Act based on purported agreement of 1/2/95 and the affidavit's power of attorney of 16/3/95. As such, there was any delay in initiating the proceedings. On appreciation of these aspects of the matter, this court is of the considered view that the fact situation of the matter is dealt with here and about established contraventions of the provisions of the PTCL Act. Hence, no grounds are made out to allow the petition. No illegalities can be attributed to the orders. After this, if your lordships were to see the operative portion of the order at page number 112, notice the learned single judge says this, there are some constructions, therefore it is necessary that there should be valuation. And without setting aside the orders passed, notice the matter is sent to the assistant commissioner to take the valuations of the property, and I am required to take the money, my lords, from the... Notice this militates against the very object of the act, or rather the very provisions of the act. Section 4 and Section 5 specifically says it should be a case of resumption and restoration, nothing short of it. And direction number 3, if your lordships were to see, my lords, if the petitioners fail to pay the value of the sites, again militates against section 4, subsection 2. Because this is a permission which is to be granted only, my lords, by the government. And the government has made a circular as to how the permissions could be granted. Lords, I have not sought for any interim orders, my lords. I am only taking out notice.
There's no notice in this. This is
I make a submission. There are several connected writ petitions, my lord.
Yes.
All the writ appeals filed against those orders have been withdrawn by them. This is the only matter. In fact, on the last date, they had sought time to take instructions whether they want to withdraw this appeal.
By
We have not withdrawn anything.
No, I am under
From
instructions to say,
3/11/2020.
I don't know, but so far as the grantees are concerned, my lords, I think we have not withdrawn any.
May I pass on one such order, my lord?
No, some of them have obviously settled.
Yes, ma'am.
So they are withdrawn.
Lord, they have withdrawn on the ground with the memo, my lord. The appellant prays to withdraw the above mentioned appeal as the assistant commissioner has passed the order in so and so as per the directions issued in WP number 23357 of 2011. In the event of the order passed by the assistant commissioner, the appellant prays to withdraw the above mentioned appeal in the interest of justice.
So therefore, the assistant commissioner must have passed an order for resumption and allotment of lands to the petitioner. That's the only order that he can pass. The only order that
In
he
this,
can pass is this.
he is also, Mr. A.M. Fernando was,
He's a party to that.
yes, my lord, one of the connected writ petitions, man. All the writ petitions, my lord, except this writ petition, which is impugned in this writ appeal, all the other writ.
No, separate lands were involved.
Please, my lord.
Sites.
And separate parcels of land must be involved in this whole exercise. Now that's built up, so the board has passed this order. Pursuant to it, the assistant commissioner must have passed some orders.
I take instructions as to what is the status, my lord.
Now file ಮಾಡಿಲ್ಲ. ಇಸ್ಕೊಳ್ಳಿ ಅದನ್ನ. I'll ascertain, my lords, because I'm short of instructions in this.
So if there is a further order that have been passed.
Lords, further orders, that's the reason. Lords, this is pursuant to the orders of the learned single judge. Assistant commissioner saying that this is the valuation. Direction number 2 and 3, if it is given effect to, Lords, it militates against section 4.2. Section 4.2 says without the permission of the government, no property can be alienated.
There are 5, I don't know how many petitions, 9, 10 petitions there.
Lords, there are multiple petitions. I just ascertain, my lords, because I don't want, offhand I will.
Pass and accepted. Now there will be only one aberration in between. That, how will you sustain that?
I just, I understand, my lords.
That counsel for the parties seek time to take instructions.
Lords, even 49 is the same, my lords. If it could be tagged along with this, same result will follow. Lords.
Same order.
Please, my lords.
23rd March. Number 13.
Hey, please.
I appear for the appellant in this matter, my lords.
My application minutes.
I appear for the appellant in this matter, my lords.
For the learned single judgment, the order page.
It's an intra-court appeal, my lords, if I may.
Since it's my
But,
application, I am starting this.
Very good.
My lord, could kindly come to the prayer in the. Yes. page 64 million. The writ petition was directed against the order of the district judge, my lord. Then the writ petition was filed. My lord will get it.
How would it be maintainable?
Page 45 minutes.
How will the appeal be maintainable?
My lords, I'm referring to the judgment of Tamanna and others versus Renuka.
That's right, on the same judgment.
My lords, on the same judgment.
227, no?
Please, my lords.
Look at your petition is under 227.
It is one under 227.
227 is an appellate power. No appeal lies against the 227.
If I may, my lords, persuade my lord's attention to the judgment of Tamanna. This is a judgment that was passed in 2009. Yeah. And my lords, without delving into greater details of the deeper considerations in that case, I'd only take, I'd only take
page 123 in the paper book.
Compilation. There is a compilation of judgments, my lords, that the learned senior counsel has already filed, and I'm referring to the same one. Yes. And in this compilation, if I may request your lordships to kindly take page number 87.
Yes.
Yeah, ink page 87.
Yes.
I'm so sorry, my lords. We could directly come to ink page 119. In fact, the conclusion in this judgment is right there. Kindly permit me to read the conclusion part in page 119. Yes. Dissecting the core issue and the reference, reframed comprehensively from any angle. The questions referred to by order dated 7 November in Saraswati batch of cases and by order dated 18 December 2007 in Karigowda case for the larger bench are answered as below. The first question referred to the larger bench by order dated 7 November 2007 in Saraswati batch of cases is as follows. Whether the finding recorded by the division bench in writ appeal so and so, by judgment dated so and so, holding that the intra-court appeal as maintainable, which is contrary to the decision of another division bench in Vishnu Ganapati Nayak case, requires reconsideration in light of pronouncement of the full bench in Pattidar's case, is answered for want of necessity that the same would not serve any gainful purpose. In 12.2, the second question referred to the larger bench by order in Saraswati batch of cases is, in view of the amendment made to section 9 and 10 of the Karnataka High Court Act, that is, in terms of Karnataka Act of 73, inserting clauses 9, 12, B and 10.4a, whether an intra-court appeal under section 4 of the Act is maintainable on the order passed by the learned single judge in exercise of the powers under 227 or under 226 and 227 of the Constitution of India is answered as follows.
There's a Constitution bench of the Supreme Court. Judges, 7 judges bench, 227, no appeal will lie. It's an appellate. The distinction is it's an appellate. It's not a original side proceedings.
The distinction, my lords, again, is that because in the Karnataka High Court Act, there is a specific inclusion under section 10, under 10.4a, which would indicate that there are powers of the division bench to go into matters where orders have been passed by the single judge.
In the original side or the original side?
On the 227.
On the original side. Let's see whether it's a 227.
Please, my lords. I could request your lordships to kindly take.
Yes, but not.
Section 10 of the Karnataka High Court Act. May I, my lords?
That's right. Original judgment, order or decree.
That's right, my lords. An appeal from any original judgment.
So it has to be exercise of original power.
Order or decree passed by a single judge in excess of powers under clause 1 of Article 226 or 227 and Article 228 of the Constitution of India.
Original judgment in decree.
That's right.
Power of Article 227 is supervisory.
Please, my lords.
It is not original at all.
That's right, my lords. And hence, this provision would indicate.
This provision will run contrary to the Constitution bench of the Supreme Court.
Whilst it remains, continues to remain, my lords, on the Karnataka High Court Act and one that is not.
It is still this is not in exercise of the original jurisdiction.
But this particular provision does provide for an appeal from an order that has been passed under Article 227.
Original order passed under the original.
I understand, my lord.
That's a misnomer because there won't be an original order in 2227.
Absolutely, my lords. In fact, that is my submission precisely. Therefore, to say that when it says that an appeal from any original judgment, order or decree, the original judgment will have, the originality of it will have to be read only in construction to the word judgment. But when the use of the word order or decree is used, then necessarily it has to be in the construction of 227. And may also, there are objects and reasons in the Act where the legislature goes on to say as to why this particular provision has been incorporated by way of an amendment. And if I may persuade your lordships to kindly look at that.
Yes. Where is that?
My lords, this is part of the Amending Act 12 of 1973, and if your lordships would permit me to read this. Read as this: at present, all applications under Clause 1 of Article 226 and 227 and 228 of the Karnataka High Court Act. I'm so sorry. This is part of the reasons, amending objects and reasons of the Karnataka High Court Act. I'm so sorry. The 1973 amendment speaks of objects and reasons to bring about that particular amendment. This amendment of section 10(4)(a) was brought about, my lords, back in 1973. Would my lords have it, please? I'm so sorry, my lords, I don't have an additional copy to pass on to the court.
Third division.
So, objects and reasons. High Court Act.
If you read it the way you are reading it, then it will run contrary to the 7th bench.
I understand, my lords, but
then there'll be no appeal. No appeal would lie against order passed in. Can only lie against original orders passed on the original side.
I understand, my lords. So typically, most judgments that have gone to the Supreme Court are also matters where letters patent were invoked. And under letters patent applicable to different high courts as modified, those were restrictive provisions.
Apart from that, that judgment rests on they trace back 227.
Yes.
So 170 of the section 170 of the supervisory jurisdiction has been transferred.
107 of the Government of India Act, my lords.
107 of the Government
Please, my
of
lords.
India Act,
Yes.
170, sorry.
Yes, my lords.
107 of the Government of India Act and said this is now a transition transited to this provision, and therefore it will not be, it's not our original site, but it's not it's more in the nature of an appellate site exercise.
Yes.
Supervisory power, which will not be amenable to judicial review.
And that was also, my lords, if I may, was specifically in the context of letters patent excluding it, and hence.
No, even the thought that you have one supervisory, then you have supervisory over supervisory.
I understand, my lords, but because of that,
how will that work?
Because of the amendment that the Karnataka legislature specifically brought out, addressing this particular issue.
This amendment has been seen in Tamanna.
Yes, my lords, this has been addressed in Tamanna. And
even here, it doesn't say that the appellate side will be looked into.
If we could look at Tamanna, my lords, going back to.
I mean, this April sometime. We'll examine it. Give your submissions on this.
I'm obliged.
Parties are at liberty to file their written submissions on the question of maintainability of the present appeal.
In the meantime, if I may also make one submission for consideration. This entire matter emanates out of a partition suit, which is currently in the final decree process. The petitioners are the majority holders of the properties.
Yes, we can't, until maintainability is decided, we can't process anything.
Very well. In the interest of possible settlement that could happen between the parties is all that I'm submitting.
Page 242 of the company, all the judgments have been noticed.
Yes.
Page 242 of the judgment side. All the judgments are noticed. And in fact, one more submission, madam. There is one judgment in favor of my learned friend. That's a division bench of this Honorable Court. But that order has been stayed by the Honorable Supreme Court, and that copy also I have given the last.
We'll address it. I'm obliged.
21st April. Number 14. Joint request adjourned to 29th April.
Just call the password.
It's a passover matter. Number 30. List 2.
Final hearing, passover matter. Call the passover. This is final hearing.
List 1, seal number 2, passover matter.
The petitioner in this case, my lords, humble submission, my lords, we had filed this writ petition with respect to PIL concerning the water level that tender should not be called. The water level was 80% was submitted by the opposite party. Later, they took a contention that water level.
My Lord, I filed it in the office, not this morning. The two episodes. So please take affidavit. My Lord, one affidavit. You are filing it now. That's nice. I filed the affidavits of respondent number 4 and the respondent number 6, my Lord.
But we are asking you something else, you're giving us something else. Volume, they says 41% of volume.
My Lord wanted to know as
We're giving you said that it was done by satellite. You said show us a satellite image.
My lord, I have produced it along with the
Where is it?
11/2/2026, my lord. I filed it this morning. It is the affidavit of.
That's what we've got 11/2/2015. It is got 2-page affidavit.
My lord, that is the affidavit of, my lord, the respondent number 6.
Yes.
For the minor irrigation department.
That's right.
My lord, I have filed the affidavit of respondent number 4, who's the deputy director. That affidavit also, along with the satellite image, to show as to how he calculated and arrived at, my lord, to say that the water spread in the lake was 50%.
My lord, sir. My lord, sir. My small submission.
Filed it this morning, my lord.
You don't have the order. What do you filed?
This is how he arrived at, my lord, to say that it was 50%.
My lord, sir. Small submission, my lord, sir. My lord, sir. A small submission, my lords. They have produced the photos of the satellite department. They have received the satellite department report, which is at page number 25th of my memo, my lords, but they have not produced before the court to suppress that.
For that,
They have signed here also that it shows that they have received the copy on the 12th month, but they are not giving before this court because it clearly shows that it is less than 50%. Only photos they have given, but the report from the same department has not been produced before this court.
They've shown satellite images.
My lords, from the same satellite image, they have the report. They have taken the report out of that file, given only photos.
Where is the report?
My lords, I have my file where memo and documents are filed, my lords. In that file, at last page number 25. Page number 25.
Yes.
I have given this.
Yes.
This is my copy, my lords.
This is what they're saying. Water spread is 857, 879, 876.
my lord, and I filed an affidavit of, my lord,
That is the actual report of the satellite, my lords. It is.
Right. So they're also saying the same.
There also it comes below 50%, my lords.
No, they're saying we've taken the average. It comes to the total.
The total is 19.5 hectares, my lords. Divided by 2, again, it is below 50% only, my lords. 40% it will come.
my lord, the affidavit of respondent number 6 may be seen, my lord. In that I have stated. I have not suppressed anything.
No, in this one.
Yes.
Which you filed, where you've given the images.
Yes.
The images show 8.57, 8.79.
Yes.
8.76, 8.26.
Yes.
Which is this?
Which is again.
They have gone by the physical assessment, my lord, the respondent number 4.
Please see the affidavit. I submit that water spread area is 19.5 hectares as per record. Captured by Karnataka remote sensing is so much.
Yes.
Where does he get it? He says, I've got a satellite image. Satellite image says 8.26.
No, my lord, it shows 8.57 in page 4.
Just see para 2 of your affidavit.
Para 2, my lord.
Yes.
My lord, the satellite images on 13/8/2025 was 8.57, which my lord gets it at paragraph in page 4.
Yes.
8.79, my lord gets it there only in the same paragraph,
Yes.
in the same page.
Yes.
Then 8.76 on 24/10/2025 and 8.26. As annexures are 13 and
Correct.
14.
How much does it come out to? Total lake is 19.5. Para 2, that's what we are saying. One page before in the affidavit.
Yes.
It says 19.5. Divide 19.5 by half.
My lord, this is as per the records of the minor irrigation department.
The area of the water spread area of this lake is so much.
That is
data shows that the water spread images on that date were 8.5. Then you say we take 50% of the total water spread area as an effective water spread area. And then they say we physically assessed what? What did he go physically assess?
My lord, that is how they physically, my lord, that is how they assess it,
What,
my lord.
he takes a periphery of the lake. We are asking you, how does he physically assess?
My lord, what instructions I got is, my lord, physical assessment means that is how they see and that is how they say. My lord, they've gone by paragraph 7 of the inland policy that I have produced as an extra.
That's right. That says 50% of the total water spread.
Yes.
Lake is 19.5 hectares.
As per the records of the minor irrigation,
So
my
what-
lord, they've.
That
This is
right.
the.
The lake area is 19.5. You
Yes.
must have 50%.
Yes.
So 50% you should have 9 point something. Hectares should be covered with water. You got covered water of 8.79, 8.26.
Yes.
Your affidavit said that we took the satellite images and then we determined it. We accept whatever you are saying.
I'm just thinking as to how to respond to this because.
It's only mathematics, no?
No, that's right, my lord. But the information that I got was this. Now.
Call the gentleman if you want.
Yes,
He'll
my
tell you,
lord.
inform you right there. How has he done this? You filed an affidavit. Your previous affidavit
Yes.
Swore that you did it on basis of your satellite images.
Yes.
And not on the basis. He said, in fact, if you remember correctly, your affidavit was that they've done it, irrigation department has done it on estimate basis. We have got our data from satellite and we have done it.
Yes.
So we told you to please file your satellite images
Yes.
and your data. Your data says that it is 8.26, 8.57, 8.79, and we take the average. Take average of anything, it can't cross 9.
No.
And your lake, you on the same affidavit, you say is 19.5. If your area is 19.5, this is not 50%. In response to our query that whether you take volume or whether you take affidavit, you said look at para 7, we take the 50% of the water spread. All right, that we accept.
My lord, may I have this on Monday? I'll keep.
Then he
both
says
your-
we went and assessed. This run did it by satellite image.
Yes.
And now he says I went and assessed and he's taken a photograph of him standing next
My
to
lord,
me.
he says that he has physically assessed and that he has confirmed it with the satellite images. My lord, may I have this on Monday?
Satellite images right here with you.
Yes, yes. My lord, may I have this on Monday? I'll keep both the officers present.
AGS 6. I'm to take further instructions. The concerned officials shall also be present for the assistance of the examiner to take instructions, and the concerned official shall also be present for assistance with the court.
Obliged.
16th February. Seal number 4, list 1.
Respondents Council.
Here for appellant, Your Lordship. Apologies for not appearing in the first one.
Yes.
Your Lordship, my instruction is that my clients are trying to settle the matter, Your Lordship.
Yes.
My instruction is that the appellants are trying to settle the matter with the respondent. And they are
not settling.
I don't know who they're settling. It's a bit like El Dorado, promised pot of gold. It's been going on since
Lordship,
2019.
there are several other. Hence, I seek a short adjournment, Your Lordship. Your Lordship, and we have engaged senior counsel also, Your Lordship. Kindly a short.
He is not present in the first hearing we have passed over.
Your Lordship.
He is not present on the one.
Your Lordship, a short adjournment. I request a short adjournment, Your Lordship. We have even. We are in talks with the respondent, Your Lordship, for settlement.
We had adjourned it on this week, on your request.
Your Lordship, kindly have it tomorrow, Your Lordship. A short adjournment I am requesting, Your Lordship.
Learned counsel for appellant seeks time to comply with office objections. Request for adjournment is made by the learned counsel for the appellant. It is. Once again, yet again, and request for adjournment is made by the learned counsel for the appellant. And the request is to give any. There's no stay.
No, Your Lordship made it clear on 25/11. On 26/11, they go to the executing court and again file an application for stay. I don't know how that's possible. Maybe that's rejected.
Anyway, that you will tell him.
Please, we'll point it. Great.
29th April.
Great.
List 2, seal number 30. So mentioned matters, seal number 56.
For the respondent matters.
Appearing to the appellants, my lord, we have engaged a senior counsel, my lord, kindly pass over.
You mentioned it.
We had mentioned it, madam.
Lord, they informed me after mentioning the matter, my lord. Kindly pass over, my lord.
Also, we can't give you on this. Then we'll have it. Put it in next week's meeting.
Yes, my lord. Preferably list 2, my lord, so that
There's no list 2 on it. If you come, you mentioned it.
Grateful, grateful.
It's 19th February.
Grateful.
Seal number 57, mentioned matter.
Appellants counsel.
Publishing list of dates. Dates.
One Srimati Gauramma, daughter of Anjanappa and Venkatamma, and Bailamma, daughter-in-law of Anjanappa and Venkatamma, had filed an application for resumption of the land under the PTCL Act. That was allowed by the Assistant Commissioner. In appeal, matter was remanded. After remand, again there was an order of resumption.
Yes.
After that, they applied for permission to sell the property under section 4(2). Permission was granted almost 1 year after the order. After that permission, the present appellant purchased the property.
Yes.
Now, my lord, in between, the respondent number, that is the Respondent number 5 and 6, that is the party in person before this court, my lord. He had earlier to these proceedings had purchased 1 acre of same property from Venkatamma. At that time she was alive. He had purchased 1 acre of property from Venkatamma. His case was, he was not knowing about the proceedings before the assistant commissioner. I'm sorry, he had purchased from one B.G. Muniappa, who in turn had purchased it from Venkatamma.
Yes.
After 2-3 writ petitions, my lord, ultimately the respondent 5 and 6 preferred an appeal against the order of the assistant commissioner, wherein at later stage I was pleaded as a party respondent. The deputy commissioner passed the order at annexure F, page 252 to 262. He reversed the order of resumption. Thereby, application of Bailamma was rejected. By that time, I had purchased this property, therefore I preferred the writ petition. WP 13-200 of 2023.
Yes.
And 13-192 of 2023.
Yes.
WP 13-239 of 23 also, Lord. Three writ petitions. As appeal was numbered, 3 numbers were given to the appeal. Therefore, 3 writ petitions were filed. Now the learned single judge holds, your lordships would get the points for consideration at page 78.
Yes.
Learned single judge records a finding that on the first resumption order, as per the rules, possession was not restored to Bailamma and Gauramma as required under law after issuing notice, etc. That was not done. Without being in possession, they could not have sought for permission. The order granting the permission was not under challenge, but learned judge records a finding they could not have made an application for granting permission. The authorities who granted the permission also, without noticing any one of these aspects, have granted permission. And my sale in my favor is also in a way set aside on the ground. Permission itself was not a proper application, not a proper proceeding, therefore sale also should go. He levies a cost of 5 lakh on the appellant and 10 lakhs on the government, which appears to have been waived on a later date. The lordships would get the directions as issued by the learned single judge. That would be from page 113 to 112, para 118. Shall I read that?
Yes.
Please, 118, I'm reading para 180. He has also enclosed an endorsement dated 17/10/2018 that had been issued to A.J. James, in which it is stated that there are no notices issued as contemplated under Rule 3(6) of the PTCL rules or under Section 39 of the KLR Act. This thus fundamentally establishes that no steps were taken in the manner specified under the PTCL rules and Section 39 of the KLR Act pursuant to the order of resumption dated 2/9/2014, and the persons in possession, James and Govindraju's family members, were dispossessed in accordance with law. It cannot be in dispute that in proceeding under the PTCL Act, a grantee or his legal heir is not in possession of the lands that has been granted to him, as he would have admittedly transferred them to another in contravention of the terms of grant under an instrument. It's only after this transfer is declared to be null and void can the transferee be evicted and the lands be restored to the grantee or his legal heir. If the persons in possession of the transferee are not dispossessed in the manner specified under Rule so and so, the question of restoring the land to grantee would never arise. However, in this case, without verifying this elementary fact as to whether the transferees who were admittedly in possession had been dispossessed, the authorities have entertained the application filed by Gauramma and Bailamma seeking permission to sell the land, which ordered to be resumed in their favor. In fact, the recommendation made by the Deputy Commissioner, which is already extracted above, they have gone on to observe that Gauramma and Bailamma were already in possession. This has been done obviously for extraneous considerations. In fact, pursuant to the complaint lodged by James, an inquiry has been ordered by the government, and the Regional Commissioner has submitted a report that there are several illegalities in the grant of permission, and steps should be taken to cancel the permission accorded. The report by itself proves the callous manner in which the officials have acted, which has resulted in HR Suresh taking advantage of the situation and dispossessing A.J. James and his wife, and also the wife and children of Govindraju, and also caused damage to their property. In fact, A.J. James has placed on record material to show that farmhouse that he had constructed has been damaged considerably, and material in this regard was also placed before the Assistant Commissioner and Deputy Commissioner, but they have not passed any order in this regard. In my view, since according to the permission by the state to Suresh, without even verifying whether the land had been resumed and restored to Gauramma and Bailamma, is the root cause of the trauma and damage caused to A.J. James and his wife, it would be appropriate to impose exemplary costs of so-and-so to be paid by the state, James and his wife, and ordered accordingly. During the course of argument, a specific query as to how Suresh got possession, it was stated that Gauramma and Bailamma were in possession and they had handed over the possession. This reply cannot obviously be acceptable, since Gauramma and Bailamma in their application seeking resumption themselves had requested Assistant Commissioner to restore the lands in their favor. It is therefore obvious that H.S. Suresh has used the sale deed executed in his favor to secure possession to himself without even verifying whether James and his wife and others have been dispossessed in accordance with law pursuant to the order of resumption that had been passed by the Assistant Commissioner. It would therefore also be necessary to impose exemplary costs on so-and-so for taking law into his own hands and dispossessing James and his wife and also wife and children of Govindraju, ordered accordingly. The costs as ordered above shall be paid within a period of 4 weeks from today. As a further consequence, the Deputy Commissioner is directed to take immediate steps to evict H.R. Suresh from the lands in question and put A.J. James so-and-so and also the wife and children of Govindraju in possession of land bearing number so-and-so from Bettadalsuru village, Jala Hobli, Bengaluru, North Taluk, Bengaluru. The Deputy Commissioner shall file an affidavit of compliance for which, though the matters have been disposed of, shall be relisted on so and so. The points for consideration are accordingly answered. As regards the finding on point 3, my lord, Roman point 3. That would be page 92. Para 88. Shall I read it? Yes. Shri Swanso sought to contend that in respect of lands temporarily granted on lease under the GMF scheme and subsequently confirmed would also be subject to condition of non-alienation for a specified period, since Anjanappa was a person belonging to scheduled caste and provisions of PTCL Act would be attracted. He relied upon the judgment rendered by the Apex Court in Guntayya's case to contend that the decision of the full bench rendered in Hambamma's case, which had approved an earlier full bench decision in Chikkakullegowda's case, has been reversed, and it has been held that even in respect of the land which had been leased temporarily for a period of non-annihilation would apply, and if they were breached, PTCL Act could be invoked. Firstly, this argument in this case would not apply, since it is already held that false claim was made in respect of Koramara Venkatamma's land on the specious plea that it was the land granted to Anjanappa. If the land in question was not granted to Anjanappa, the question of invoking PTCL Act would not arise at all. However, this question has been raised. The same will be considered. In Siddhamma's case, a division bench of this court, while dealing with a case in which land was allotted under GMF scheme, had thereafter been confirmed, and in that context had held that Rule 43, so and so, which related to the grant of lands to person to whom lands has been previously leased, would not make Rule 43G, which imposed the condition of non-alienation, applicable. The judgment was approved by full bench in Chikkakullegowda's case. However, in that case, full bench was not concerned with the land granted under the GMF scheme and was actually dealing with a case where lands had been temporarily leased to certain persons belonging to scheduled caste and scheduled tribes before the commencement of Mysore Land Revenue Amendment rules and were subsequently granted under Rule 433. Full bench in that case approved the ratio laid down by the division bench in Siddhamma's case in the context of Rule 43G not being applicable to a land granted under Rule 433. But since the case was not concerning a land granted under GMF scheme, same cannot have no application directly. This decision of the full bench was approved by another full bench in Ambamma's case, which held that the period of 15 years non-alienation cannot be applied for lands granted under Rule 43J. However, this judgment has been reversed by the Apex Court in Guntayya's case, and therefore the argument is being advanced that even in respect of lands granted under GMF scheme, if the grantee is a person belonging to scheduled caste and scheduled tribe, PTCL Act would be applicable. It must be noticed that Guntayya's case also, the Apex Court was dealing with a case in which lands has been granted to persons belonging to scheduled caste, scheduled tribes who had been given the lands on a temporary lease and thereafter granted them permanently, and was not dealing with land which had been granted under GMF scheme. In my view, therefore, reliance placed on the judgment can be of no avail. The then government of Mysore, much before the rules were framed, which brought in Rule 43G, had issued a government order on 11/4/1942, which sought to increase the lands under cultivation and thereby enhance the production of food grains, which were in short supply. In this government order, it has been stated as follows. The committee, which was appointed by the government in October 1940 to investigate this question, stressed the need for increasing the output of paddy and toggery and other pulses in the state for meeting local requirements. The total area under paddy had varied from about 7 lakh acres to 8 lakh acres a year, according to the conditions of rainfall and water supply and tax, and trade statistics show that Mysore has had to import every year 10 to 20 lakh pallas of paddy valued at 50 to 100 lakhs of rupees. In view of the international situation, the problem of supply of rice has become very acute, owing to difficulty of obtaining supplies from the places from where the state was importing hitherto. It has therefore been imperatively necessary to devise measures to grow more paddy locally so that the requirements of the people of the state may be satisfied. A scheme has already been sanctioned by the government for a period of 3 years, by which the deficit is intended to be converted in part by increasing the production in 21 talukas of the state. There is, however, a large extent of unoccupied irrigable lands which has not yet been brought under cultivation, and the disposal of these lands has been slow, mainly due to inability of the applicants to pay the value of the lands. Government therefore considered that some special concession should be granted to persons intending to bring these lands under cultivation, and that normal procedure of darkhast should also be simplified so that the delay in grant of lands may be minimized as far as possible. Government are accordingly pleased to direct the Deputy Commissioner may be empowered to lease out unoccupied irrigable lands under channels and tanks for temporary paddy cultivation for a period not exceeding 3 years, with concession as to the payment of assessment as noted in the margin. The persons who bring the land under cultivation will have the option of purchasing the lands for a reasonable upset price at the end of the period of lease, that is 3 years. They are further pleased to direct that paddy cultivation on marshy lands may be encouraged by waiving the assessment, provided the lands do not use channel water directly. It must be noticed here that the government did not make any special reservation to persons belonging to depressed classes, nor did they extend any concession to them specifically. This scheme was thrown open to public in general and was made available to any person who came forward to put unoccupied lands to cultivation, given the background that there were severe shortage of grains and imperative steps were to be taken to increase the production. The order in fact states that the normal procedure of darkhast should be simplified so that delay in grant of lands were minimized. Thus, the government order was in essence a relaxation to the normal land grant rules, which contained various restrictions on granted lands. If the lands were permitted to be occupied for putting the same under cultivation, and if the occupier is given the option of purchasing the same after 3 or 5 years, if he has bought the lands leased to him under cultivation, it is obvious that such kind of grants cannot be imposed with restrictive clauses which would be applied in respect of normal grants. It must be kept in mind that under the normal land grant rules, the procedure for reserving the lands to depressed classes and allotting it to them because they belong to depressed classes would make it a granted land, which would in turn attract the restrictive clauses. However, if the lands are allotted in relaxation of the rules, obviously the restrictive clause can have no application. It must also be stated that a division bench of this court in writ appeal number so and so has held that lands granted under GMF scheme cannot be considered as granted land as defined under PTCL Act, and the PTCL Act can have no application. This decision has also been followed in WP so and so. A coordinate bench of this court in so and so followed the said decision and held that provisions of PTCL Act would be applicable. Inapplicable in respect of lands granted under GMF scheme, and this decision was affirmed by the division bench disposed on so and so, which is also confirmed by the apex court in SLP number so and so. In the light of the fact that the apex court has confirmed the decision of the division bench holding that provisions of PTCL Act would be inapplicable to lands granted under GMF scheme, the arguments of so and so cannot be accepted. There are, however, a few disturbing facts of this case which brings to light the harassment that a citizen has had to endure, and it has become necessary to pass orders remedying the injustice caused. As already noticed above, an attempt was made to usurp the land granted to Koramara Venkatamma by contending that she was the wife of Anjanappa and has sold the land after his death in contravention of the terms of the grant, even though the land had been granted to her distinctly and independently. This crucial and key aspect was totally lost sight by the authorities, and the lands were ordered to be resumed. After the order of resumption was passed, authorities have committed a blunder which has resulted in catastrophic consequences on innocent people. Under the provisions of PTCL Act, more specifically 51A thereof, Assistant Commissioner is empowered to make an order to take possession of such land if he had been satisfied that transfer of the land granted was null and void. He is also empowered to take possession after evicting all the persons in possession in prescribed manner. Thus, after holding an inquiry and on being satisfied that a granted land has been transferred in contravention of the terms of the grant made, the Assistant Commissioner can declare that the transfer is null and void and thereafter also take possession of the land by evicting all persons who are in possession of the same, however in the manner prescribed. Proviso to so and so in fact stipulates that no order shall be made unless the person to be affected by the order is given a reasonable opportunity. Under section so and so, he is thereafter required to restore the land to the original grantee or his legal heir, and only if that is not practicable, the land is deemed to have vested in the state, and the state will have to grant the land to persons belonging to a scheduled caste. And state has framed so and so rules. Rule 3 is quoted. Notice to be given before taking possession and then restoring the possession. In that sub-rule 6 may kindly be seen at page 106.
Yes.
After inquiry, the Assistant Commissioner shall consider all the objections raised and pass an order giving reasons for his conclusions. Thereafter, he may take possession of such land after evicting the persons in possession thereof in the manner provided under section 39 of the Karnataka Land Revenue Act 1964 and take further action as provided under section 5. That is, the learned judge holds that this procedure was not followed. Without following this procedure, the further application made for permission to sell the land, all those proceedings, in a way, without application of mind, is what
restoration is not happening. This is the only way to restore land.
That is the only way to restore the land, and therefore all those proceedings, according to learned single judge, he holds without application of mind, without basis, etc. Two things, my lord. The submission that PTCL Act provisions will not be applicable to GMF scheme is not something which would be a correct thing in view of the judgment of the Supreme Court in Guntaya's case, where similar condition reasonings were noticed and it was may be permitted to read the judgment in full, my lord. Facts also have some relevance.
Yes.
Please. That is in page 35, page 229, printed page 229, para 2. Under the Karnataka Land Revenue Amendment Rules 1960, certain lands were granted to members of SC/ST. Initially, these lands were given to them on temporary lease, and later, by virtue of Rule 43J of the Rules 1960, these lands were given to them permanently with a restriction that grantees shall not alienate these lands to third parties for a period of 15 years. These lands were granted to them during the period 1959 to 65. Karnataka So-and-so Act 1978 came into force on 1179. Section 4 of this Act is to the effect that any transfer of land made either before or after the commencement of the Act in contravention of the terms of grant of such land or law providing for such grant shall be null and void, and no right, title or interest on such land shall be conveyed nor be deemed to ever to have conveyed by such transfer. The persons who obtained the grant of government lands, contrary to the condition regarding alienation, transferred the properties to third parties. In some cases, even the transferees had effected further transfers of such land to others. Section 5 of Act 2 of 79 empowers the Assistant Commissioner to pass appropriate orders for restoration of the land to original allottee in case of any transfer was effected contrary to Section 4 of the Act. Section 5 of Act 2 of 79 provides that an Assistant Commissioner, on an application by any interested person or on information given in writing by any person or so moto of such inquiry, if he is satisfied that the transfer of any land granted is null and void as provided under subsection 1 of Section 4, may by order take possession of such land after giving reasonable opportunity of being heard to the person evicted and restore the land to the original allottee. An appeal is also provided against the order of the Assistant Commissioner under Section 11 and shall have overriding under Section 11. The Section 11 of the Act further states that Act 2 of 79 shall have overriding effect over other laws. In all these cases, the original allottees who were either scheduled caste or scheduled tribe transferred the property to third parties without obtaining previous permission of the government. Later, the original allottees or their successors in interest filed application before the Assistant Commissioner praying for restoration of land which were transferred contrary to Section 4. The Assistant Commissioner, after conducting inquiry in these cases, held that all transfers were null and void and directed restoration of possession to original grantees. The affected parties filed appeals and those appeals were dismissed by the appellate authority. Those orders were challenged before the High Court and the learned single judge confirmed the orders of the appellate authority. Aggrieved by the judgment of the learned single judge, writ appeals were filed which came up before the division bench. An argument was canvassed on behalf of the transferees of such lands that the lands in all those cases were covered, were granted under Rule 43J of the rules, and it is not specifically provided under Rule 43J that there shall be any restriction on alienation or the restriction imposed was not valid and foreseeable. The division bench of the High Court thought it fit to refer the matter to full bench as certain conflicting opinions were expressed by different benches of the same High Court. The relevant portion of the reference order is so and so. One of the important questions that arises for consideration in these writ appeals is as to whether an authority granting the land under 43J of the Karnataka Land Revenue Rules can impose any condition at the time of making grant that the grantee shall not alienate for land for 15 years when 43J does not provide for any such condition. A further question also arises on the effect of condition imposed on in the Sagoli chit by the Asildar that the grantee shall not alienate land for 15 years when such condition was not imposed by the order of the authority making the grant. The full bench held that in all these cases, lands were allotted under Rule 43J and therefore there should not have been any condition restricting the alienation by the grantees. The full bench also held that conditions stipulated under Rule 43G were not applicable to the grants made under Rule 43J and therefore conditions imposed by the Tahsildar in Sagoli Chit restricting the alienation of such lands by the grantees was not sustainable in law. Aggrieved by the said decision, state as well as affected parties have filed these appeals. In order to appreciate the contentions urged before us by the parties on either side, it is necessary to go into some relevant provisions contained in rules of 1960. These rules of 1960 were intended to regulate the allotment of the government lands to certain category of persons. As regards grant of lands, the revenue officers were given certain powers. The Tahsildar to whom the power of Deputy Commissioner has been delegated may grant not exceeding 2 acres of rainfed wetland or 4 acres of dry land, provided that the market value of such land, including the value of trees thereon, does not exceed 300 rupees. The Assistant Commissioner thereon does not exceed, in charge of the Taluka is also given power to grant land not exceeding 2 acres of land fit for garden cultivation or wetland with assured irrigation facilities. Rule 43 provides the format of application form for grant of land and cultivation. Rule 43B states that no land with more than 25 reserved trees in acre shall be disposed of for cultivation except under special orders of the government. Rule 43C, 43D gives certain preference to an individual who is poor or bona fide agriculturist, political sufferer, etc. It also provides that the lands which are in control of the Revenue Department may be leased to schools, colleges, training institutions, and also to farming societies registered under the Karnataka Cooperative Societies Act. Rule 43E says that lands available for disposal in a village shall be reserved for grant of different categories of persons eligible for such grant, and where land available for disposal in any village is less than 10 acres, the entire land available shall be reserved for grant to the applicants belonging to scheduled caste and scheduled tribes who are ordinarily resident in the village. Where the extent of land available for disposal in a village is more than 10 acres, a minimum 10 acres shall be reserved for grant to the applicants belonging to SC/ST. Rule 43F prescribes the order of priority of the extent of land to be granted. Marginal note to Rule 43G says that grant of land under the preceding rule shall be subject to certain conditions. Rule 43G reads as follows. Grant of land under the preceding rule shall be subject to following conditions. In the case of grant of lands to applicants belonging to scheduled caste, scheduled tribes, and to other applicants who are unable to pay the occupancy price on account of poverty, occupancy price may be waived up to rupees 200 and the balance recovered in three annual installments. In the case of grant of land to 2 applicants who are ex-servicemen, the occupancy price will be waived up to the extent awarded by the government under military concession rules. In the case of grant of land to free of occupancy price, the grant shall be subject to condition that grantee shall pay contribution or betterment levy in respect of the land and the value of trees standing on the land. Where the grant is made free of cost or is made at a price which is less than the full market value, the grant shall be subject to condition that the land shall not be alienated for a period of 15 years from the date of grantee taking possession of the land after the grant, provided that such land may be alienated with the previous sanction of the government and subject to such conditions that the government may specify. If the government is of the opinion that in the circumstances of any case it is just and reasonable to permit such alienation, either for the purpose of acquiring some other land or for any other purpose, provided further that nothing in this clause shall apply to alienation of land in favor of the state government or cooperative society as security for loans obtained for improvement of the land, etc. Continue tomorrow. May I make a request, my Lord? Tomorrow I am not here. Can it be Monday, Tuesday, any day, my Lord? Tomorrow I am not here.
I don't know, Monday we have put some matters if you want to.
Any other day, tomorrow I'm not here.
Give them a day.
Please.
Interim order to be
Request, sir. This vexatious litigation, he has also mentioned in the same writ appeals, set of writ appeals that 10634, last time I mentioned, he has taken a stay on KLR Act in that court. And there he is referring this status quo order, and that also may be brought, listed along with this.
We'll finish this one.
The Lordship's
Along with this, so that, and multiplicity of proceedings.
This you can make a mention after this matter.
With your Lordship's kindly, serial number 26. The interim order may kindly be continued.
Interim order to continue.
Serial number 26, there is an urgency. Lordship may kindly call it on Monday, Tuesday. Because
26.
unit in part has been stopped. There are a large number of employees who are sitting outside the plant.
26 is what?
No, my lord, mine's matter.
Monday, Tuesday.
Pleadings are
It's a
complete.
contempt petition. It's a contempt petition.
Contempt. There is a contempt also in spite of the Autumn law. They have not in fact allowed us to open the.
WP 6690 of 23, my lord. Connected with the
Petition
contempt.
needs to be heard in fact.
What is the urgency?
What matter? Monday, Tuesday.
What is the urgency?
Not the crushing being, it is in fact crushing of iron ore. Crushing has been completely stopped and large number of employees are sitting outside the plant.
Give it in a day, we can do it.